This video is for people who want to bring or defend an employment tribunal claim about disability discrimination at work. It explains who counts as disabled in the employment tribunal. What I'm going to tell you is quite complicated, and you may find it helpful to pause the video at times and replay it. At the end of the video, there is a slide which tells you where you can get more information. There is also another video which explains what happens when there is a dispute about whether or not a claimant is disabled and how the tribunal will deal with it. An important thing to remember when considering whether or not someone is disabled is timing. In order to be able to make a claim for disability discrimination, a claimant needs to be disabled at the relevant time. The relevant time is not the date the claimant submits their claim to the tribunal or the date when the tribunal hearing is taking place. Instead, the relevant time is when the claimant says their employer discriminated against them. This might be a time when the employer treated the claimant badly because of their disability or because of something arising in consequence of their disability. We call this an act of discrimination. Or it might be a time when the claimant says their employer should have done something more to support them as a disabled employee. We call this making a reasonable adjustment. There is a special test for what counts as a disability in an employment tribunal claim. The test is found in the Equality Act 2010. It is different, for example, from what counts as being disabled when claiming benefits or to get a blue badge for parking. The Equality Act says a disability is a physical or mental impairment which has a substantial and long-term adverse effect on a claimant's ability to carry out normal day-to-day activities. It sounds complicated, but it is easier to understand when broken down into three parts: physical or mental impairment, ability to carry out normal day-to-day activities, and long-term. I'm going to tell you about each of these parts in turn. The first part of the test is that the claimant must have a physical or mental impairment. Many disabled people do not like thinking of themselves as having an impairment and instead prefer to think of themselves as being differently abled to people who do not have the same condition. Although the Equality Act uses the word impairment, another way of thinking about this is that the claimant must have a physical or mental condition or difference in physical or mental ability. All kinds of physical and mental impairments or differences will count. The slide shows some examples, but there is no set list. I am now going to move on to the second part of the test, which concerns how the claimant's condition impacts on their daily life. The Equality Act says that a claimant's impairment will only count as a disability if it has a substantial adverse effect on the claimant's ability to do normal day-to-day activities. The word adverse just means bad or negative. Substantial simply means that the effect must not be really small. Sometimes you will hear people say the effect must not be minor or trivial. Normal day-to-day activities are things we do in normal everyday life. Putting these things together, what this part of the legal test means is that a person's impairment will only count as a disability if it makes their daily life more challenging. As I said previously, normal day-to-day activities are things we do in normal everyday life. Although when talking about this, we use the phrase normal day-to-day activities, the activities which can count do not actually have to be things which are done every day. For example, Flying in an aeroplane to go on holiday counts as a normal day-to-day activity at a tribunal, even though it is not something most people do every day. The slide shows some examples of normal day-to-day activities, but there is no set list. Claimants can use other examples too. In the last slide, I explained that a claimant's impairment will only count as a disability if it makes their daily lives more challenging. Here I want to explain that there are two different ways this can arise. The first way is because their impairment stops them being able to do something normal. An example would be where a person has very bad arthritis in their knees and cannot climb stairs at all. This person cannot do a normal day-to-day activity, climbing stairs, because of their impairment. The other way an impairment makes daily life more challenging is where the impairment makes it harder for a person to do something normal. An example would be where a different person with the same impairment, arthritis, can only climb stairs a few steps at a time because they're in a lot of pain. This would count as having an adverse effect on that person's ability to do a normal day-to-day activity, because the impairment means they climb stairs more slowly and in pain, even though they can climb them. If, however, they were able to climb to the top of the stairs only slightly slower than someone without the impairment and without much pain, the adverse effect would not be bad enough to count, and the person would not be disabled under the Equality Act. When a tribunal assesses the effect an impairment has on a person's ability to do day-to-day activities, it will ignore any medication, aids, or workarounds that the claimant uses to help them manage. Another example is useful to understand this. Imagine someone who suffers from anxiety but takes medication to help them manage their symptoms. Without their medication, the person is too anxious to travel on public transport. However, with medication, they cope well with buses and trains. The tribunal would base its decision on whether the person is disabled on the position without medication. In this example, because the person is prevented from being able to do a normal day-to-day activity using public transport without their tablets, they would be disabled. By the way, there is an exception for if a person wears glasses or contact lenses. A person's eyesight is assessed when wearing glasses. This means that most people with standard eyesight variations do not count as disabled. The final part of the test concerns how long-lasting an impairment and the effects it has are. Where a claimant has an illness or injury that stops them from being able to do normal things, but it is not long-lasting, the illness or injury will not count as a disability. An obvious example of this is where someone breaks their arm and is unable to write while their arm is in plaster. If they recover fully within a few months, they will not count as a disabled person because their condition was not long-term. 12 months or a year is the time frame a tribunal uses. There are three different ways an impairment can have a long-term effect on a person. The first way is where an impairment is lifelong. A typical example might be cerebral palsy, which arises at birth. The second way is where the effects of an impairment keep coming back. We say they are recurring. A typical example might be depression. Lots of people get depression for a few months at a time and then get better. But for some people, it can come back several times in their lives, although they have periods of being well in between. The final way is where the claimant has a medical condition that gets better. If the condition lasts for 12 months or more, and during that time has had an adverse effect on the claimant's ability to carry out day-to-day activities, it will count as a disability. A person need not necessarily wait 12 months before they can call themselves disabled, however. If it seems likely from an earlier date that their illness is going to last for more than 12 months, they will count as disabled from that point in time, i.e., when it became likely that they would be ill for 12 months or longer. When assessing this, a tribunal will usually consider what the person's doctor was telling them about when they would get better. I've now finished telling you about the 3 parts to the test, but I want to finish this video by briefly telling you about some special rules for particular medical conditions. There are some medical conditions which count automatically as disabilities. These are shown on the slide. There are also special rules for severe disfigurements. They also count as a disability, even though they don't physically stop people doing normal day-to-day activities. There are also special rules for progressive conditions, such as multiple sclerosis and muscular dystrophy. People with these conditions are treated as being disabled straight away, even though the condition may not yet have an adverse effect on their ability to carry out normal day-to-day activities. There are also special rules that mean some conditions will not count as disabilities. They are known as excluded conditions. They are addictions to alcohol, nicotine, or any other substance, except if the addiction was originally the result of taking medically prescribed drugs or other medical treatment, a tendency to set fires, steal, physical or sexual abuse of other persons, exhibitionism and voyeurism, hay fever, and tattoos and piercings. There are lots of places to look if you want further information. In this slide, I have identified the main pieces of legislation that apply and where to find them, as well as some other places to look. A document that will be very helpful to read is the statutory guidance on matters to be taken into account in determining questions related to the definition of disability. It is available on the gov.uk website. I would also encourage you to seek legal advice. Thank you for watching. I hope you have found this video helpful.